I'm Rodger Citron. I'm a professor at Touro Law Center. This is a Touro Law Review podcast, and this one is for all you administrative law fans out there. I'm talking to David Franklin. He is a professor at DePaul Law School. And David, thank you for joining us. And we might as well get right into it.
Yeah, thank you for having me.
Thank you. David, let's start where we always do. Tell us a little bit about yourself, please.
Yeah, sure. Well, I've been teaching administrative law along with other things for about 20 years here at DePaul. I've also spent a couple of years as an appellate litigator. I was Solicitor General of the state of Illinois for a few years. And way back when, I was a law clerk at the Supreme Court, clerking for Justice Ruth Bader Ginsburg. And I've certainly followed administrative law and the Chevron saga for more years than I care to admit.
All right. And you've set us up perfectly because we we're here to say a eulogy for the Chevron doctrine. In the Supreme Court term that just ended, the Supreme Court overruled Chevron in a case or two cases. They're both known as Loper Bright, and we'll get into that. To start with, can you tell us a little bit about what the Chevron doctrine was and what it meant in administrative law?
Sure. So Chevron is one of the most often cited cases in the history of the Supreme Court. But it actually started out as a fairly technical environmental law case about the Clean Air Act. That's a federal statute that, among many other things, requires that emission limits and other technological limits be imposed on what the statute calls stationary sources of air pollution. And at the risk of getting too into the weeds, I'll try to sort of sketch out what was going on in Chevron, because I actually think it's a pretty interesting story once you get past the seemingly daunting technical details. So initially, the EPA, the Environmental Protection Agency, determined that each emitting source within a plant, like say each smokestack, counted as a separate stationary source. But then under the Reagan administration, actually under an EPA administrator named Anne Burford Gorsuch, who was Neil Gorsuch's mother, the agency decided, no, we're going to say that the entire plant, the whole facility, can be counted as a single stationary source, almost as if you place an imaginary dome over the facility. And this became known as the bubble concept. Now, before your audience's eyes glaze over, why does any of this matter? Well, what really matters is that the agency had changed its position, had changed its mind about what its governing statute meant. Okay, so what happens next? Well, the lower court, the DC Circuit Court of Appeals, in an opinion by then Judge, later Justice Ruth Bader Ginsburg, writes an opinion exhaustively surveying the legislative history of the Clean Air Act and telling the EPA, sorry, guys, you got the law wrong. Each smokestack has to count as its own stationary source. The case gets appealed to the Supreme Court. And based on the confidential papers that we now have access to, frankly, the justices don't know what to do with it. Three of them end up not participating in the case for various reasons. So the court has a bare quorum of 6 justices. And in the end, Justice John Paul Stevens writes an opinion that says, gosh, the Clean Air Act is really complicated. The issues here are technical. We can't really say for sure what stationary source means, but the agency's bubble concept looks reasonable to us. So we're going to let it stand. And in the course of issuing that otherwise unremarkable and frankly rather boring administrative law decision, Justice Stevens announces a now famous 2-part test. So the first part of the test, the first step, is that the court has to ask whether Congress has spoken clearly in its statute. If Congress has spoken clearly, that's the end of it. Then Congress's word is the law. But if Congress hasn't spoken clearly, if the statute contains a gap or an ambiguity, then we move to step two, and the agency is allowed to fill that gap with an interpretation of its own, so long as that interpretation is reasonable. So nobody really paid much attention to the Chevron decision at the time. It was viewed as basically in line with the court's general approach to administrative law. But soon the case became quite famous, and that two-part test has since been cited literally tens of thousands of times.
And one of the reasons why we're talking tonight, shortly after the Loper Bright decision, which overturns or overrules Chevron, came out this year, you wrote a piece for Slate, and that's available on our website and will be part of the package with the podcast. We'll have a link to that. But Justice Scalia is an important part of the story, which picks up after the decision and helps explain, the importance or the significance that Chevron came to assume. Can you say a little bit about that part of the story and that part of the history?
Sure. So Scalia was not yet on the Supreme Court when the Chevron decision came down, but he joined the court a few years later. And as you say, it was really Justice Scalia who was largely responsible for lifting the Chevron case out of obscurity. He started trumpeting it as a general approach to interpreting regulatory statutes. The idea of deference to agencies became associated with Chevron. Scalia wrote a well-known law review article about it, and he championed the Chevron decision in numerous opinions, both majority and dissenting opinions, over the next 20 or so years. Basically, whenever other justices tried to place limits or preconditions on Chevron deference, Scalia would loudly object and say, no, this is the framework, let's stick with it.
Yeah, and two things. One is, of course, Chevron was 1984. At the time, he was then Judge Scalia on the DC Circuit, I believe, and of course, subsequently was put on the Supreme Court by President Reagan. And then this is also in your Slate article. I believe the law review article that you mentioned was 1989, if I remember correctly.
Right.
And then the substantive part of the question here is, so why did Scalia champion Chevron? And I just want to sort of point out that there's a couple different ways that we could understand, Chevron. There's sort of a political science view. There is, there is, for someone who prided himself on being a textualist, that seems to be part of, part of the story for him. And of course, there is also, as a DC Circuit judge and then as a justice, he was a judge. And that's part of the story too. And I just wanted to sort of, take your pick. How do we understand Justice Scalia's, for most of his career, being a champion of Chevron?
Yeah, it's a fascinating question. And as I say in my Slate piece, I think there are three possible reasons why Scalia was such a big fan of Chevron. And we can kind of rank them from the least to the most cynical. The least cynical, the most principled reason is that Chevron made a pretty good fit with Justice Scalia's overall jurisprudence, which was about, first of all, empowering the president to lead a muscular executive branch, while at the same time limiting the discretion of unelected federal judges. And Chevron, at least in theory, does both of those things. Now, if we want to be a little bit more cynical, uh, the second explanation, and actually Scalia copped to this himself in that 1989 article, he said, look, one of the reasons why I can be a fan of this Chevron doctrine is that it rarely requires me to embrace a statutory interpretation that I don't personally agree with. Because I, said Scalia, am pretty good at determining that a statute is clear after all at step one, which of course means we never get to step two, and there's no need for deference to agencies. Scalia was a clever reader, maybe too clever by half sometimes, of statutory texts. And then the third explanation, if we want to be really cynical, but I think this has a lot of explanatory force, frankly, is the one that you're sort of gesturing at with your question, which is that, look, Scalia and other conservatives on the court were fans of Chevron during the Reagan-Bush era, when deferring to agencies meant deferring to a lot of business-friendly, deregulatory rules, as happened in the Chevron case itself, right? But then when you've got Democrats like Clinton and Obama in the White House, and at the same time you have a conservative majority cementing itself on the Supreme Court, the right wing of the court, and even Scalia himself, starts to express misgivings about Chevron. In fact, that trend of sort of sidelining the Chevron case accelerated to such an extent that the Supreme Court has not relied on Chevron one time even since 2016. In fact, it's barely even cited the decision. So if you get an administrative law case in the court, even before the formal overruling of Chevron last month, or earlier this month, I guess, even before that formal overruling, Chevron really wasn't an active player at the Supreme Court level. The federal government had stopped relying on it in their briefs. Chevron had become the sort of classic that everyone learns about, but nobody really pays attention to. It's like nobody watches Citizen Kane anymore, right? Now, lower courts would still cite it fairly often, but it was pretty clear that Chevron was no longer a major player at the Supreme Court level.
Yeah. And well, we'll come back to that because that point, of course, is made by Chief Justice Roberts in the majority opinion in Loper Bright, and it's also addressed by Justice Ginsburg in her dissent. That is how it is that the Chevron sort of fell off the map in the last 8 years or so. But rather than go there, why don't we tell, I guess, the most recent part or chapter in the story, right? Which is, or go to that part, which of course is the Loper Bright decision itself, which was before the court, which squarely presented what should we do with or about Chevron. Can you tell us that a little bit about the case and what the court did?
Sure. So the Loper Bright case was really a case about a very obscure regulation. The Chevron case was actually an important environmental law decision. I don't think anyone would say the Loper Bright decision is all that important. It has to do with a statute that concerns who pays for the costs associated with federally mandated monitors who board fishing vessels to make sure that the vessels are not overfishing. But never mind all that. It's pretty clear that the court intended this case as a vehicle to revisit and, as we see, of course, overrule Chevron. Now, just a slight footnote, they don't overrule the actual stationary source Clean Air Act holding of Chevron, but they overrule the methodological, two-step framework that I mentioned earlier. And why do they do that, or how does the majority do that? Well, the majority opinion by Chief Justice Roberts relies mainly on the language of the Federal Administrative Procedure Act, the APA, And this is a statute that governs judicial review of agency decision making. And the APA tells federal judges that they are to, quote, decide all relevant questions of law. Um, well, the court says if courts are supposed to decide all relevant questions of law, then what are they doing deferring at step 2 of Chevron to the agency's interpretation of the law? Now, we can argue with that interpretation of the APA. I don't think it's particularly persuasive, but that, for the most part, is the legal basis for the overruling of Chevron. Alongside that, there's also broader language in Chief Justice Roberts' opinion that sort of takes a swipe at the constitutionality of the Chevron framework, saying, wait a minute, it looks to us like it's inconsistent with what Chief Justice John Marshall said all the way back in 1803 in the Marbury versus Madison case. You know, it is emphatically the province and duty of the judicial department to say what the law is. At one point, Chief Justice Roberts even says, agencies have no expertise in interpreting statutes. We do, meaning the courts. We're the ones with that expertise, which I'm sorry, I have to say is really just an arrogant and self-regarding thing for a judge to say, especially when it comes, Rodger, to statutes that involve a high degree of technical or scientific complexity. Not at all clear that judges have a comparative advantage at interpreting those kinds of texts, but that's basically what the majority opinion in Loper Bright says.
And just to sort of finish the portrait of Loper Bright, there are concurrences by 2 justices, I believe Justice Thomas and Justice Gorsuch, and they absolutely vote with the majority, but they have something else to say or something more to say. And I don't know that we need to dwell on it, but I think it's important to get a sense of where they were coming from with respect to Chevron. Can you just sort of complete that portrait or picture for us?
Sure. So both of those justices that you've mentioned, along with Brett Kavanaugh, have made no bones about their opposition to Chevron for years now. Justice Thomas, as he has done many times before, writes to say flatly that he believes Chevron is unconstitutional because it usurps the power of the federal courts and it gives executive agencies power that they don't rightfully possess to interpret statutes. He mainly cites his own past opinions, which he's fond of doing, as authority for this, but he has a well worked out theory. Again, I don't find it especially persuasive, but to the effect that Chevron is unconstitutional. Although I'll just note parenthetically that Justice Thomas did write one famous opinion holding applying Chevron, and not only that, but holding that when an agency changes its position under Chevron, that new position that the agency has taken should prevail over an intervening court decision. So hard to see how his current perspective is consistent with that famous majority opinion that he wrote.
And I just want to, for those who are really, want to dig deep, this is, I believe, the Brand X is
Brand
the case.
X, yeah.
Is the case. And you'll find it if you do Brand X, Chevron, and Justice Thomas in your search on however you do legal research. BRAND.
That was the one case where Justice Scalia was actually somehow more anti-Chevron than Justice Thomas. But let's not go down that rabbit hole. And then you asked about Justice Gorsuch's concurring opinion in Loper Bright. He writes what is, to my mind, a fairly frightening opinion, frankly, saying that precedent isn't really law, and therefore courts don't have that much of an obligation to adhere to precedent, and that Chevron doesn't deserve any stare decisis effect, even though it's been on the books for 40 years, and as I say, it's been cited tens of thousands of times.
And so this is a case that much is made now in 2024 of the 6-3 court that is 6 justices appointed by Republican presidents, 3 appointed by Democratic presidents, and the vote here breaks down exactly along those lines. Super fast. I think she's so formidable in this area. Uh, Justice Kagan dissents, and what are the key points of her dissent? I think it's important to put a competing view or a disagreement with the majority decision on the table as well here.
Sure. Right. So Justice Kagan, first of all, says Chevron has become part of the fabric of American administrative law, and we should not lightly overrule something that is that foundational. You were making this point earlier, Rodger. She points out that it's a little bit, I don't know, underhanded, my word, not hers, for the majority to sort of um, successively take swipes at a precedent like Chevron, sort of give it the death by a thousand cuts, and then finally, with the final swing of the axe, say, well, there's no problem overruling this because the decision has become so weakened over time. Well, sure, you weakened it. She equates this case with a case from First Amendment law that I'm very familiar with because I argued it in the Supreme Court and lost it, in which the court held that it violates the First Amendment for public sector unions to require members and non-members alike to pay for their representational activities. And Justice Alito was the author of that decision called Janus. And he did the exact same thing. He said Janus is no longer entitled to stare decisis effect because it has become weakened over the years. Well, it was weakened by a succession of Justice Alito decisions that were clearly laying the groundwork for it to be overruled. So there's a stare decisis point that Justice Kagan makes. But on the merits of the thing, she points out, I think, fairly persuasively, that there's nothing inconsistent between Chevron and either the Administrative Procedure Act or the Constitution, that courts can undertake to determine what a law means by, in appropriate circumstances, deferring to expert judgments made by agency decision makers. At the end of the day, what Chevron was based on, and Justice Scalia was very eloquent about this, was an assumption about what Congress wants. So that when Congress writes a statute, that statute is never going to be able to anticipate all of the unforeseen circumstances in which it will be implemented. And so Congress's assumption, according to Chevron and according to Justice Scalia and now Justice Kagan, is that when those unforeseen circumstances arise and are truly not provided for by the statute just doesn't speak to them, why ask an unelected generalist, not technically expert federal judge what the statute means? Why not turn to the decision makers that Congress chose to vest executive authority and to sort out how to apply the statute under those conditions? There's nothing inconsistent there with the APA's command that courts interpret relevant statutory provisions, or indeed with Marbury's command that courts say what the law is. So in a nutshell, I hope that wasn't too complicated, that's basically what the dissenting justices said.
Yeah, and I just really want to punctuate. This is, for me, the reason why I find the dissent so powerful or forceful is the expertise point. And this will also, I think, segue into, and let me just pause there because I believe it's in this dissent that in the end she says, it's like, I have a growing collection of these. And of course, looking at, I think it's her dissent here, because we've had the emergence of the major questions doctrine with an important case this term, last term, the prior term in an EPA case. And 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 uh, and so the themes that are in the dissent that she articulates in the dissent, are, of course, are points that she has made elsewhere, and I think again makes them quite well. But I see them sort of centered on the idea of expertise, and I think it's important not to lose sight of it. I know you mentioned it. I just wanted to sort of punctuate it. Um, but then, and this will really take us back to the majority opinion, um, and I there is a way that Chief Justice Roberts can be interpreted, can be read as saying, well, the agency still has a chance to make its presentation, to make its arguments about how to interpret the statute if we are in a situation that would have, that we called step two under Chevron. That is, if there's lack of clarity, silence, ambiguity. It's just that we're going to take a different approach. We're going to go back to what's known as you well know, the Skidmore case. And isn't that all the argument would be something, isn't that all we've done here? That is, we've replaced the command of Chevron step two with Skidmore deference. So really, we haven't done all that much. The agency still gets the opportunity to present its view on how the statute should be interpreted. I, I hate to be sort of flip. Do you buy it? That reading of the majority opinion.
Yeah, I mean, I think on the face of things, that's a perfectly reasonable interpretation of the opinion. Loper Bright says, okay, from now on, it's up to courts to figure out what these statutes mean, full stop. But the court goes on to say that doesn't mean that courts can't give respectful consideration to an agency's views about the meaning of the laws that the agency administers. That you can call that deference, you can call it respectful consideration or whatever, but it's going to depend on a number of factors. It's going to be a sliding scale, right? How long-standing is the agency's position? How consistent from time to time? Was it contemporaneous with the underlying statute's passage? Did the agency engage in notice and comment or formal adjudication in arriving at its position, and so on? In fact, I would go further. The majority opinion in Loper Bright suggests that Congress is free to signal that courts should, in fact, defer to agencies. If Congress writes a statute that says, the Federal Energy Regulatory Commission shall set prices for wholesale transmission of electrical power at such rates that it shall deem just and reasonable, or what have you. That is a strong signal to the courts to defer to what is essentially a policy judgment of where those rates shall be set. So on the face of things, absolutely. Add to that, as we said earlier, that Chevron has kind of been a dead letter for a better part of a decade anyway, and you could say Loper Bright doesn't make all that big of a difference. But there's always a but, right? I think in the hands of a right-wing, pro-business, anti-science, anti-expertise judiciary, particularly in an age where litigants can go judge shopping, right, by filing in friendly districts and then seeking universal injunctions, right? There's just no telling where courts will go with this newly official word from the Supreme Court that they are the ones who get to interpret regulatory statutes from the ground up. So doctrinally, it may not be all that big of a change, but I think practically, it may just be yet another nudge in the direction of undermining the administrative state.
Yeah, and this is, one admin law professor to another. Something that, when I do the first day of class and do this sort of overview, I talk about, well, there's historically, I said there's been 3 years of administrative law. There was the New Deal era in which the agencies, were treated as, impartial, genuinely expert, and therefore there was a great deal of deference. And then there was the 60s and 70s when it may have been, quote, a partnership, as I think a judge on the DC Circuit judge once wrote or said. But of course, it's clear that courts were leading that partnership. And so there was, real rigor in judicial review of agency action. And then Chevron itself seemed to be this third era. I don't know if you can put exact dates, but it was sort of, we can't make it impossible for the agencies. And now, when I think to say the court with the 6-3 court, I'll just use that as the shorthand, it seems that we're in a fourth era in administrative law, at least, as I understand it. And I think, I guess my question is, when on the first day of class, when I talk about the fourth era, is it fair to view this current 6-3 court as really attacking the foundations of the administrative state in the 1930s? That is, really as sort of seeing it as opposed to or deconstructing so the foundational premises of the administrative state. And I mean it sincerely. Is that a fair question? And I just want to say that this is for our listeners, major questions doctrine, the Jarchese case, even the arbitrary and capricious case, I think Ohio versus EPA, that was part of, the last round of decisions in this year's term. There is a question in there. There may even be several, but I'll stop just so I can sort of let you talk.
Yeah, I mean, look, Occam's razor suggests that the simplest explanation might be the right one, and it certainly is a natural thing to observe that so many of these decisions, you've named many of them, right, have in common the sort of uprooting or upsetting of foundational understandings about administrative law that have governed for several generations. You could add to that list, right? I mean, a case like Touro Law, right, which comes very close to undermining the kind of New Deal settlement as of the 1930s, that says, with respect to at least some kinds of regulatory issues, Congress has the power to place those in the hands of so-called independent agencies that are at least not formally under the thumb of the president. Well, the case that I mentioned, Touro Law, says Congress can't do that when it comes to the Consumer Financial Protection Bureau because that's a single person headed agency. They reserve the question of whether to undermine the principle of independence altogether. But I think, they're loaded for bear on that question. Collins' decision does something similar. Decisions under the Appointments Clause, like Arthrex, are all of the same piece. So yes, the conservative justices on the court, and beyond that, right-wing Trump appointees on courts like the Fifth Circuit have such a profoundly anti-regulatory, anti-government worldview. I mean, read Justice Gorsuch's concurrence in Loper Bright, and other cases, full of invocations of the word bureaucrat, written with an almost audible sneer in place of a word like expert, right? So I think that factor is very much in play. The other factor that helps explain so many of these recent decisions, Rodger, including the ones you've mentioned, is the aggrandizement of the power of the courts, right? Agencies can't be trusted to interpret statutes. That's Loper Bright. Agencies can't be trusted to adjudicate securities law violations. That's the Jarchese case. Only the courts can do that, right? So there's a kind of self-aggrandizement on the part of the judiciary that goes back, frankly, I think, to the 1990s and the jurisprudence of Anthony Kennedy and others. that you can see in these decisions as well. Now, look, defenders of these decisions will say, no, they're not about that. They're about adhering to the text of the Constitution. I don't particularly buy that. Or they're about ensuring that there's a unitary executive. Okay. But I don't think I buy that either, for reasons that we can go into if you'd like, or that they're about defending individual rights. You know, the other thing about Justice Gorsuch's concurrence is he cherry picks a whole bunch of cases in which it was the lone individual against the power of the bureaucrats, right? So he's casting himself as the champion of the little guy. But of course, the overwhelming majority of these challenges to agency rulemaking come from very well-lawyered, well-resourced corporations and business groups. And those are the interests that are primarily served here. It's really about protecting those business interests and expressing a deep suspicion of expertise and science, I think, more than anything else.
Yeah. I I lost you for about a minute. I don't know if that was true on the recording. I think it was on my end with the recording being unstable. You picked up again talking about in the 1990s. Is it fair to say, just in case, that it happened for the entire recording or for all of us on the recording, you were talking about this sort of anti-science explanation for
there's
the
an
current court?
anti-science explanation, and there's also a pro-judicial power explanation,
Oh,
right?
yes, yes,
That
yes, yes, yes,
that
yes.
these kinds of decisions ought to rest, not with the executive branch, but also not with Congress, frankly, although Congress could, in theory, assert itself. This is a court that understands that we have a profoundly gridlocked Congress, a polarized Congress, that often can't bestir itself to pass a Mother's Day resolution. And so, power abhors a vacuum, right? So into that vacuum, you see the court, right? Newly emboldened, 6-3 supermajority, saying these kinds of decisions are for us to make. We're the ones, the courts are the ones that get to interpret regulatory statutes. The courts are the ones that get to adjudicate securities law disputes. That's the Jarkezi case and so forth. So those are the trends that I see.
Thank you, because I think we've sort of covered, if you will, the case, uh, tried to suggest some sort of broader ways of understanding it. The last thing, and understanding that no one has a crystal ball. What do you think a post-Loper Bright world will look like? Um, I'll just leave it there.
Yeah, well, as I say, it's all about the judges who implement the new regime, right? If you look again at some of the decisions coming out of the Fifth Circuit, say the Mifeprestone case, or the case striking down the entire funding mechanism for the Consumer Financial Protection, I'm not too optimistic. Now, it has to be said that both of those decisions by the Fifth Circuit and some others were reversed by the Supreme Court. And some will say that means the Supreme Court is somehow moderate, right? I don't think a reasonable observer would believe that, right? What you have is right-wing judges on lower courts pushing the envelope, testing the waters, and sometimes getting slapped back by the Supreme Court saying, no, here you've gone too far. Look, Rodger, as I said earlier, I don't think Loper Bright by itself will make a huge amount of difference. I don't want to be alarmist about this case in particular. Remember, Chevron was already more or less a dead letter. But I think it's part of a trend, right, of inviting lower courts, district courts, circuit courts, to push the envelope, to test the waters all the more. And I think that trend, which Loper Bright is a part of, is going to make it harder for agency officials to do their jobs, to protect our air, our water, food, our workplaces, and many other features of our society that we've come to depend on.
Yeah. Thank you. as they say in gymnastics, as well as in podcasting, I think you stuck the landing. And we're going to end there. But thank you
Well,
so
thank
much
you,
for your
Rodger. It's been a
time.
pleasure talking with you.
Likewise, thank you so much.